Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing all important aspects pertaining to nationality. We had two important videos already, the first being just sanguinis and just soli, and then we discussed the concept of nationality in detail with definitions and illustrations. In my today's video, we are going to discuss modes of acquisition of nationality and how a person can lose the nationality. Now, when it comes to modes of acquiring nationality, you might be thinking that there are two modes, one just soli, the other one is just sanguinis. Now, the question is, are they the only two ways to acquire nationality or there are any other ways? That's what precisely we are going to discuss in my next two slides. We are going to discuss as many as 7 modes of acquisition of nationality. The first being by birth or just solely theory. By taking birth in a particular state, a person gets the nationality of that particular state is all about just solely, and many of the countries in this world follow this theory, and the biggest example for that is USA. Not going to invest too much time on this because I have already made an independent video on just soli and just sanguinis. You can refer the same for this particular requirement. The second mode is by naturalization. If a particular person spends the required number of years of a particular state to become national of that particular state, then by naturalization he can become national of that particular state, for which he need to complete the requirement of that particular state to become national of that particular state. Now, how can a person get naturalization? He may get naturalized via marriage, legitimation, option or acquisition of domicile, or through appointment as government official, or through grant on the application of the state, or maybe via adoption. With all this, a person can get naturalized with a particular state, and with that he can become national of that particular state. Now, the next important question is whether states are having obligation to grant nationality on the basis of naturalization. The answer is no, which is what held in the case law of Nottebohm case 1955, where the real and effective nationality doctrine was laid down. Now, here it was pronounced that state has no obligation in granting nationality to a person through naturalization if that person has no relationship with that particular state. So it is very important for a person to have a clear relationship with that particular state. Only then via naturalization he might get nationality, and it is not an obligation to a particular state. And secondly, if there is a question of double nationality, in that case they will see with which state he has real and effective relationship. Only that state nationality will be given and he will lose the other nationality. That is how you have to see. There should be real and effective relationship to prove the nationality of a particular nation, and when it is double nationality, the one where he has the real and effective relationship will be considered as his nationality. The third mode of acquisition of nationality is by resumption. Imagine a person has left nationality of a particular nation, and then after some time he wants to regain that. By following certain procedures required by law, he can resume back his nationality, and that is the third mode of acquisition of nationality. Fourth way is by subjugation. Imagine there are two states, state A and state B. Now, state A acquires state B. By doing so, the state B nationals will get the nationality of state A because they are being acquired. The fifth method, where a state is giving up all its rights, property, territory, etc. For example, there is state A and state B, and state A gives up all its right, property, territory, and state B takes them. In that case, all the state A national will become the nationals of state B. The sixth mode of acquisition of nationality is by option. This happens mostly when a particular state is divided into two or more parts, and if the nationals are given a choice to choose any of the nationals of that two or three parts, in that case that is known as nationality by option, and this mostly happens when there is exchange of territory. The seventh one is by registration. By following certain law of land, if somebody is getting or acquiring the nationality, that is known as nationality by registration. Now, if a person can acquire nationality in so many ways, can a person lose nationality? That is what we are going to discuss in this particular slide. where Opinium has given 5 important modes of losing nationality, and let us discuss them one by one. The first being release. If someone is making application to get released from a particular nationality, he can be released after following certain procedures. But one important thing that we need to remember here is Article 15 of Human Rights Declaration, where it is very clearly mentioned that every person need to have a nationality. So if someone is asking to release him from a particular nationality, he should be having double nationality so that one state can release him. The second mode of losing nationality is deprivation. When can deprivation happen? If a person is not following the law of land, a state can end him his nationality. That is possible. For example, as per American laws, if somebody joins the armed force of a foreign state, that might result in deprivation of nationality. So that is what you need to remember. And the third one is expiration. If somebody is leaving his nation and lives in another state for a long time, with the expiry of time, he might lose the nationality of his original state. Now, one important aspect here is also the Article 15 of the Human Rights Declaration, where a person cannot be expired his nationality until and unless he gets another nationality. That is one important aspect you need to remember. The fourth mode of losing nationality is renunciation, and here the most important requirement is the person should have double nationality and he can renounce one of them. Now the fifth method is substitution. If a person can substitute one nationality with another, in that case he can lose one nationality by substituting it to another. Now the most important case law as far as nationality is concerned is case law of Nottebohm case or Liechtenstein versus Guatemala, for which I am going to make an independent video because this is a beautiful case law which we are going to understand in detail. Throughout the video, one important aspect that you need to mention in your answer is Article 15 of Human Rights Declaration. Every person should have a nationality and nobody can deny the right of changing nationality of a person. Now we are discussing so much about statelessness or double nationality, so it's time for us to discuss that particular topic. So in my next video I am discussing both the concepts. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you're watching my video, and thanks again.